Hello everyone, this is Nazarat Fatima and you're watching LiveLaw. Have you ever been in a situation where you desperately needed an internet connection, but due to a certain reason you had no access to it? Have you ever wondered what if you were conducting some important research online and suddenly the screen reads no internet connection? The sad part of the story is, even if you haven't, there are people who were deeply affected because of the internet shutdowns. A petition was filed by Software Freedom Law Centre India, which challenged the internet shutdowns in various states across the country. The bench, comprising CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala, heard the matter. The counsel for the petitioner, before going into any other details, straightaway came to the point that the internet shutdown was a pan-India concern. He also referred to internet shutdowns in the state of Rajasthan, which was done because of an examination being conducted online. The Supreme Court had, however, refused to entertain this petition for the reason that it would make more sense if the petition was filed in the High Court of the same state under Article 226 of the Indian Constitution. The petitioner in the present petition also highlighted the issue concerning the state of Rajasthan. However, the bench was not inclined towards the case, as again, it said that the case can well be heard by the High Court of Rajasthan. So what was the difference between the petition filed earlier and the one filed presently? And why would it be brought up by anyone again, even after it was refused by the Supreme Court already? The answer is that the petitioner in the present petition submitted in the Supreme Court that the issue of internet shutdowns was a pan-India concern, and the earlier petition only talked about one state. He submitted in the court, and I quote, "The reason why we stand on a different footing is because the earlier petition was not pan-India." It somehow did not convince Justice P.S. Narasimha entirely. He said, and I quote, "In the earlier petitions too, we asked the parties to go to the High Court because in the High Court they would be able to interact with the parties and see what the reason for shutting down the internet was. It is not happening in one go over the country. People have actually approached us. We have asked him to go back to the High Court. Similarly, you too can go to the High Court and High Court will hear the matter." Hearing this, the petitioner went forward with his submissions and tried to convince the court to take the matter. He submitted, and I quote, "These particular states, the states that we have pleaded, West Bengal, Rajasthan, Gujarat, Arunachal Pradesh, they have a recurrent issue of imposing internet shutdowns when it comes to cheating in exams. The point of us coming to the Supreme Court is so that pan-India directions can be issued. Counter affidavit has also been filed by the union." Finally, a question was posed at the counsel for the petitioner by the Chief Justice of India, D.Y. Chandrachud. He asked if any standard procedure or rules were followed for imposing the internet shutdowns, and the counsel replied that the counter affidavit has been filed by the Ministry of Communication, which talks about the suspension rules that are applicable in such cases. The bench was finally convinced, as the counsel for the petitioner was successful at establishing the fact that it was a pan-India issue and did not affect a particular state. The matter will now be heard on a non-miscellaneous day after 3 weeks. Thank you for watching. If you find the content useful, please like and share the video. Also subscribe to the channel and don't forget to press the bell icon for notifications. For a better experience, download the app LiveLaw.